Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And today has been a juicy day for XRP. Hopefully you guys all saw my previous video in which we covered and discovered the XRP pump. It went to about 158 already in that video, or just after that video. I'm not exactly sure, but it was crazy, and it's really a hectic day for XRP. A lot of people are talking about it right now, and I think the pump was just kind of necessary for people to showcase. Even though it might have looked like a pump and dump, even though it might not, blah, 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 doesn't matter. It just showcased once more, XRP is no stablecoin. There's still a ton of people who will pick up XRP at these quote-unquote higher prices. And even though they're being sued, a lot of people know what is going on. And maybe, just maybe, some billionaire just pressed the XRP buy button a little bit too early. Maybe they all, agreed to buy it on the same date, and this guy just, flooped. He didn't buy too much, but he bought just a little bit too early. Well, having said that, there's been quite a lot going on with the Ripple v. SEC lawsuit. A couple of things are noted right here that happened today. You can see May 5th is 177 to 183, so quite a lot of documents came out. Now, I'm assuming that it's actually divided by 2. I'm not exactly sure why everything is in pairs of 2, to be honest with you, but we got everything over on Twitter by James Fillon. I'm not sure if he buys these things or if he finds them in any other way, shape, or form. I'm actually not sure how that's all supposed to work, but he basically posted everything, so we got it as well. And I can quickly share that over on Twitter, but again, by watching these videos, you most likely have all the stuff that you need. So let's quickly check it out. We have, first of all, the response in opposition to motion. So let's quickly check out here. We have the opposition to individual's motion to fully seal memoranda. We have the filed its memorandum of law in opposition to the defendant's motion to dismiss declarations, exhibits, and memorandum attached, see below. And we have the Ripple files opposition to the SEC motion to compel turnover of privileged legal advice documents. So which one was first now? We have response in opposition to motion, declaration in opposition to motion, memorandum of law in opposition to motion. So the order here, I'm not exactly sure about. We can actually maybe do it in order that he posted it to make sure that we are accurate in that specific sense. So first of all, the first one I guess we saw was right here, this little thread. SEC v. Ripple. Ripple files its opposition to the SEC's motion to compel turnover of privileged legal advice documents. So this specific situation, I can already tell you guys, is basically Ripple telling the SEC that they don't really want to give over their documents. That's basically what it comes down to. And they already did that. The SEC came back and said, well, we do want you to give it. And then Ripple again came back in. It's just basically a back and forth right now about those documents. And for those having difficulty opening the PDF, you can see it right here. It is not that long, not that difficult, but also not that extremely relevant because we covered most of this yesterday. The Second Circuit has squarely held that disclosures of legal advice that predate litigation do not support a privilege waiver. Pretty strong. Ripple has not placed legal advice at issue, and I think that was actually it, right? So some might say it's pretty weak. Let's quickly see if we have anything else. No, we do not. Some might say it's pretty weak. Well, I just mostly noticed that Jeremy Hogan and a couple of the others I've spoken to are basically saying Ripple has a point with the points they're making, and they're trying to fight to the bitter end, but there's a good chance the SEC on this specific argument is going to win if it's the case that they really are telling the truth. Here it says the SEC's argument is wrong on the law and the facts. The purported selected disclosures that the SEC relies on were all made outside the context of litigation, where the fairness doctrine has no application. Binding Second Circuit precedent ambiguously establishes that disclosures made outside the context of litigation do not trigger waivers of privilege as to undisclosed communications. Quote, we hold, therefore, that the extrajudicial disclosure of an attorney-client communication, one not subsequently used by the client in a judicial proceeding to his adversary's prejudice, does not waive the privilege as to the undisclosed portion of the communication. What this actually means in just easy English, even though I'm not a native English speaker, by the way. Wait, actually, before we say that, make sure you press the like button and make sure you subscribe to the channel if you haven't done so already. My question of today is, do you think Ripple will actually win this lawsuit? I personally think so, but let me know down below what you think. This, in easy English, basically actually just means that Ripple thinks that the SEC's argument as to why they have to give over their documents, which basically is Ripple used the documents. By the way, the documents in reference here are the ones that Ripple got legal advice from some sort of attorney, let's call it that, some sort of advisor, and they've used that financial advice selectively. And if they have, well, then the SEC has right to also get that information. That's what the SEC says. Ripple says, well, in the case that we're talking about here, everything you're saying is not relevant to the case. And again, I'm not a legal advisor, I'm not an attorney. I don't actually know how strong these arguments are, but to me, it sounds pretty logical, right? But again, I have no idea how strongly this stands up. But what they're saying does sound pretty interesting. Then I guess the second part, let's quickly see what exactly comes after that, because again, I kind of messed up the order. We have SEC v. Ripple letter motion to seal. A motion to seal is actually not that interesting if you were to ask me. It's just basically to close some stuff up. Exhibits A and B to the SEC's letter are two legal memoranda addressed to Ripple from 2012. These memoranda were also filed under seal in connection with the SEC's memorandum of law in support of his motion to strike Ripple's fourth affirmative defense, and Exhibits B and C to the declaration of Daphne Waxman in support thereof. Ripple has moved to permanently seal these documents. That motion is currently pending before Judge Torres. We respectfully request that to conserve judicial resources and avoid inconsistent results, this court ordered that those documents be sealed in the interim pending Judge Torres' decision and permanently sealed or unsealed in accordance with that decision once it is at issue. So in this case here, it's just they put up a motion to seal, which basically means they want something to be sealed, some document. It's not actually going to, but he's basically saying, or they're basically saying, well, because we've already put that forward to the judge, I think the day prior, they already put that, we actually want to make sure that these documents, are sealed right now. So please just seal them already and then unseal them if the judge actually rules against, which is also quite logical in my own opinion. Now let's quickly see, whatever, I just quickly scroll through here exactly the last one. So then a little bit afterwards, there's actually more coming because I think I started a little bit too early. There's one of yesterday that I also showcased now, whatever. SEC v. Ripple, SEC files opposition to individuals' defendants' motion to fully seal memoranda regarding legal advice. So once more, things are getting pretty funny here. Ripple wants to seal some documents. They don't want those to come out. They don't. And the SEC is now opposing that little letter of the SEC asking the judge to seal those documents. The SEC once more does not agree with that. So the SEC is basically saying, well, there's relevant factual and procedural background. And again, it's just basically back and forward about the financial advice that Ripple received. And the financial advice is key here because we do believe that if Ripple received financial advice about XRP, and in the advice is basically so that Ripple could have not really have known because they asked properly whether or not XRP was a security. And if they asked this financial advisor, with the intent basically, with no intent of actually claiming XRP was security, but they basically just asked some questions and did not already allege that XRP is a security, so how could they sell it? They basically just came up there, asking him what's going on, and they said, no, XRP is definitely not a security. If that was the case, everything would be good. It's only if Ripple came up there saying, hey, XRP looks a lot like a security, we think it is, so can you help us out? How can we legally frame this? Or how do we legally form it so that it's not a security? That's basically what the SEC is looking for here. The SEC is looking for some dirt on Ripple that they discussed in one of their meetings with a financial advisor or in one of the pieces of advice or discussions they had with a financial advisor. Of course, they also want to have the financial advisor's official verdicts as they want to know everything that was said in there. They basically just want to dig up as much dirt as possible. And again, the reasonings you can already see for yourself or already kind of feel. You don't have to go too far into that. That's basically just the SEC trying their best to get those documents. It's just nothing really crazy. That was that one right here. And the last one is SEC v. Ripple. SEC News filed its memorandum of law in opposition to the individual defendants' motions to dismiss. So motion to dismiss is again coming from Brad Garlinghouse and Chris Larson recently. It's basically them wanting to dismiss the lawsuit against them specifically. And we're not talking about Ripple, the entire lawsuit. We're talking about the lawsuit is in three parts against Ripple, Brad Garlinghouse, and Chris Larson. They want to kind of dismiss the whole Chris Larson and Brad Garlinghouse part because they're saying it's not really relevant, nor is it really necessary. And I would agree with that in a good part. However, I do not agree that or think that this motion to dismiss is actually going to work out because all those attorneys I've spoken to said a motion to dismiss almost never gets granted. It's just, you try. Because then it's just really easy, but it usually doesn't work out because there is most likely some piece of relevance in there. And if there is, then it needs to stay. And then again, the SEC just now, I say then again, quite often, whatever. The SEC just now gave their opposition as to why this motion to dismiss should be dismissed. Yes. Now, that's a little bit of the breaking news update. Here was the chart. And again, as you can see, I say too often. The 17th, there's going to be John Dean's reply to the SEC/Ripple. That's the first thing that's going to be coming up, which is going to be on Monday, I am assuming. Yes, it is going to be on Monday. And then afterwards, again, the hearing and stuff like that. It goes on and goes on and goes on. But this is the most important for right now. I'm still figuring out a proper way to actually live stream the whole event once more. I'm able to get in a call, but I'm not sure if the live stream itself is going to work that day. So I might have to go and get myself some cell phone coverage and basically live stream from my phone if necessary, so I don't have to use the hotel Wi-Fi here. Because even though I have 50 Mbps, megabytes per second, it's very inconsistent because in a hotel apparently you have shared, right? You have shared internet. Or I'm gonna have to look through the whole Dubai here, see what place has stable freaking internet, and then stream from, I don't know, outside or something like that. Not exactly sure. I might even have to just stream from my phone. I might have to do some uncomfortable stuff. But again, I'm doing a phase review at 150K anyway, so I need to get more comfortable with you guys. So whatever, I'm gonna try my best to get it done, all right? I got you. Don't worry about it, right? Dusty BC, never gonna let you down. You already know, though. You already know. Make sure you press the like button and subscribe if you are enjoying the daily crypto updates. Let's quickly see what else we had here. Once more, guys, XRP not going anywhere. It's a lot better than Bitcoin in the front of energy consumption. One thing you should really understand is that the SEC is right now going after XRP/Ripple. True. But maybe eventually they're going to go after Bitcoin purely for the energy consumption, and we'll be the last ones laughing. Just think about that for a couple of seconds here. We might really be the last ones laughing because XRP is one of the most efficient cryptocurrencies in that matter. Not saying it's going to end up really well, but I'm just saying, hey, think about that. Think about that. Think about that. The rest, I guess, let's quickly see. XRP lawsuit update. Ripple opposes SEC's motion to strike, citing cherry-picked facts. Again, Ripple saying that's not the truth. And XP holders petition to investigate Jay Clayton obtains required number of signatures. It went pretty damn huge, to be honest with you. 30 freaking thousand to investigate Jay Clayton. William Hinman dropped the case against XRP/Ripple and let Gary Gensler investigate it all. That's pretty damn interesting. And did I have anything else? Yeah, this one, kind of a summary of the entire lawsuit, but we'll cover that in another day. Just want to get these videos out as soon as possible so you guys can enjoy them and hopefully, do something with the information that you've just gathered. A lot was going on here. A lot was going on. And I'll update you guys Monday again when there's more news of the Ripple v SEC lawsuit. I am pretty freaking excited about them, though. Not gonna lie. And I think in general, the price goes up whenever there's positive things in the lawsuit happening. Doesn't mean that Monday's going to be another positive date, but generally speaking, just a lot of positive stuff is happening, and Ripple keeps on winning because, well, the judge also knows the SEC is kind of weak here with whatever they're saying. They're basically alleging that every sale of XRP is a security sale. That's going to be a hard one to really prove. That's going to be a hard one to make the judge believe, specifically if they're doing all this cherry picking themselves and doing this lying here and there. Yeah.